so we know who the regulators are. Now let's talk about how anyone actually gets held accountable. And this is a chapter one genuinely enjoy, because it's where law stops being abstract. 5 areas of focus. First, the private liability theories, contract and tort. How does a company get sued by an individual for a privacy failure? What must the plaintiff prove? Second, we'll separate civil from criminal. Most privacy exposure is civil, but not all. There are statutes with criminal penalties and you should know which. Third, and this one is genuinely modern, the fiduciary theory. The idea that data holders owe duties of care and loyalty the way doctors and lawyers do. It's contested. It's also where academic thinking is heading. Fourth, the workhorse. UDAP Section 5. We touched on it. Now we'll take it apart properly and see how the FTC built a privacy regime from 13 words. And fifth, enforcement in practice. Federal agencies, DOJ, state AGs, the CPPA, cross-border coordination through GPEN, and the self-regulatory enforcers like PCI DSS. By the end, you'll understand not just what the rules are, but what happens when you break them. Let's start with the 2 ways a private party can come after you. Contract and tort. They're fundamentally different, and knowing which one you're facing changes everything. Contract liability is about broken promises. You agreed to something, you didn't do it. The elements are simple. There's an agreement, there's a breach, there are damages, and in privacy, the contracts are everywhere. Your data processing agreement with a vendor, your terms of service, your business associate agreement, even your privacy notice, arguably, though courts have gone back and forth on that. Tort liability is different. It's about duties you owe regardless of any agreement. You never promised the person anything. The law imposed the duty anyway. The classic privacy torts come from common law. Intrusion upon seclusion, which is essentially prying into someone's private affairs in a way a reasonable person would find offensive. Public disclosure of private facts. False light. And appropriation, using someone's name or image commercially without permission. Let me show you the practical difference. A vendor mishandles data. Your contract with them gives you a breach of contract claim, and it probably has an indemnity clause and a liability cap you negotiated. The consumer, who has no contract with that vendor, has to find a tort theory instead. So here's my question. Which one gives you more control? The one you wrote? That's why contract drafting is privacy work. Let's draw a line that matters more than people expect. Civil versus criminal. Civil liability is about compensation. Someone was harmed, someone pays. The standard of proof is preponderance of the evidence, meaning more likely than not, 51%. The remedy is money, or an injunction ordering you to stop. Criminal liability is about punishment. The government prosecutes. The standard is beyond a reasonable doubt, which is much higher, and the remedy can include prison. Now most privacy enforcement is civil, FTC actions, state AG actions, class actions, all civil. But there are criminal hooks, and you should know them. HIPAA has criminal provisions. If you knowingly obtain or disclose protected health information wrongfully, that's a crime. And it escalates if you did it under false pretenses or for commercial gain. And people have gone to prison for this. There are cases of hospital employees snooping on celebrity records and facing charges. ECPA has criminal provisions for unlawful interception. The Computer Fraud and Abuse Act criminalizes unauthorized access. Here's the nuance I want you to catch. The same conduct can trigger both. A rogue employee steals patient records. HHS can pursue civil penalties against the hospital for inadequate safeguards. DOJ can prosecute the employee criminally. Same incident, 2 tracks. So when you assess risk, ask both questions. Who pays and who goes to jail? Now let's get intellectually interesting. This one isn't settled law, but it's shaping the conversation. A fiduciary is someone who holds power over you and must use it in your interest, not theirs. Your doctor, your lawyer, your financial advisor, the relationship is asymmetric. They know things you don't. You have to trust them. So the law says, we'll impose duties beyond ordinary contract. The information fiduciary theory, associated with Jack Balkin at Yale, asks a simple question: why isn't a data company a fiduciary too? Think about it. Your search engine knows what you're afraid of. Your health app knows your cycle. The asymmetry is enormous. You cannot meaningfully monitor what they do. You have to trust them. That looks exactly like a fiduciary relationship. Now the counter-argument is serious. Your doctor's interests aren't structurally opposed to yours. An ad-supported platform's interests sometimes are. Their revenue depends on doing things you might not want. Can you be a fiduciary to someone you monetize? Here's why this matters for the exam and for practice. The theory is showing up in legislation. Some proposed federal bills use duty of loyalty language. California's age-appropriate design code has a best interest standard for children. That's fiduciary thinking in statute. So it's not just theory anymore, it's leaking into law. Let's unpack those two duties because they're doing different work. Duty of care is about competence. Handle the data well, secure it properly, don't be careless, and honestly, we already have this in various forms. The GLBA safeguards rule is a duty of care. The HIPAA security rule is a duty of care. State data security statutes are duties of care. Duty of loyalty is the radical one. It says don't use the data against the person's interests. And notice what that does. Care asks, did you protect it? Loyalty asks, did you exploit it? Let me give you a concrete contrast. Imagine a mental health app. It has excellent encryption, perfect access controls, no breaches ever. Duty of care, satisfied, but it sells inferences about depression to advertisers who target vulnerable users with predatory offers. Loyalty, violated. Do you see? Perfect security, terrible loyalty. The data was never leaked. It was just used against you, by design. That's why loyalty is the more powerful concept and the more contested one. Because a duty of care can be satisfied with engineering. A duty of loyalty constrains the business model. I sat in a workshop where a product team genuinely could not answer the question, would our users be upset if they saw this? Not, is it legal? Not, is it secure? Just, would they be upset? That's the loyalty question. Hold on to it. Let's ground this. Negligence is the most common tort theory in data breach litigation, and it's worth knowing why it usually fails. Negligence has 4 elements: duty, breach, causation, damages. The plaintiff must prove all 4. Duty first. Does the company owe a duty of reasonable care to protect this data? Courts have increasingly said yes, especially where there's a relationship. But it's not automatic, and some courts have balked. Breach is usually the easiest part. If you didn't patch a known vulnerability for 18 months, that's a breach of reasonable care. Standards like NIST and ISO get cited here to define what reasonable means. Causation. Did your failure cause the harm? And this is harder than it sounds. The plaintiff's identity was stolen, but their data was in 6 breaches that year. Which one caused it? And damages. This is where it collapses. What did the plaintiff actually lose? They spent time freezing credit. Is that compensable? Court split. There's also something called the economic loss doctrine, which in many states blocks recovery for purely financial harm in tort. So here's the pattern I want you to see. Companies rarely lose breach cases on the merits. They lose on the risk of the merits, and they settle. The threat of class certification is the leverage, not the verdict. Alright, this is the workhorse. Let's take it apart. Section 5 prohibits unfair or deceptive acts or practices affecting commerce. That's it. No mention of privacy. And yet it is the foundation of American privacy enforcement. Deception first because it's easier. A representation, omission, or practice that is likely to mislead a reasonable consumer and it's material to their decision. Now watch how this applies. Your privacy notice says we never share your data with third parties. You share it. That's deception. You didn't break a privacy law, you broke a promise. I always tell clients this and it lands hard. The FTC didn't require you to write that privacy notice, but once you wrote it, they'll hold you to every word. Your own document becomes the standard you're judged against. Unfairness is broader and stranger. 3 elements: substantial injury to consumers, not reasonably avoidable by the consumer, and not outweighed by countervailing benefits. Notice, no promise required. You can be unfair without ever saying anything. Terrible security with no privacy notice at all, still unfair. And here's the multiplier. Every state has its own UDAP statute, often called a little FTC Act. So state AGs have this same tool. 1 vague sentence, 51 enforcers. That's why Section 5 matters. Let's look at what these enforcers can actually do to you, because the tools differ and that changes strategy. The FTC investigates through civil investigative demands. It can seek injunctions. It negotiates consent orders. But here's a limitation you must know. The FTC generally cannot get civil penalties for a first-time Section 5 violation. It has to get an order first, and then penalties apply if you violate the order. That's why FTC settlements have 20-year compliance terms. The order is the enforcement mechanism. There are exceptions. COPPA has direct penalty authority, so does the safeguards rule. Rule violations carry penalties. Section 5 alone generally doesn't. DOJ handles criminal prosecution and litigates on behalf of federal agencies in court. When the FTC needs to collect penalties, DOJ often files the case. State AGs are different animals. Many have direct penalty authority from day one. They can seek restitution, and they coordinate. When 40 AGs form a multi-state working group, the settlement negotiation is not a negotiation. Let me give you the practical read. Which enforcer worries a general counsel most? Historically, the FTC. Increasingly, the AGs, because they move faster, they penalize directly, and there are 50 of them. Now let's meet something genuinely new in American privacy. A dedicated privacy regulator. The California Privacy Protection Agency was created by CPPA, and I want you to appreciate how unusual this is. Every other American privacy enforcer does privacy as one item on a long list. The FTC also does antitrust and advertising. State AGs do everything. The CPPA does privacy. Only privacy. Why does that matter? Expertise and focus. A dedicated agency builds deep institutional knowledge. It writes detailed regulations, and the CPA has been prolific. ADMT rules, risk assessment requirements, cybersecurity audit mandates. Now, enforcement is shared. The CPA has administrative enforcement authority. The California AG retains civil enforcement authority. Both can act. Let me talk remedies. Under CCPA, administrative fines run per violation, with a higher tier for violations involving minors, and per violation is doing enormous work in that sentence. If a violation is counted per consumer, a systemic failure affecting 1 million people is arithmetic you don't want to do. There's also a limited private right of action, but only for certain breaches of unencrypted personal information, with statutory damages. And the cure period, CPRA made it discretionary. That safety net people relied on is thinner than it was. Data doesn't respect borders. Neither, increasingly, do regulators. Let me start with the problem. A company in the US harms consumers in Canada, the UK, and Australia. Each country's regulator has jurisdiction over the harm, but limited reach over the company. Evidence sits abroad, witnesses sit abroad. What do? GPN is one answer. The Global Privacy Enforcement Network, established in 2010 under an OECD recommendation. It's an informal network of privacy authorities from dozens of countries. It's not a treaty. It has no binding power. What it does is enable cooperation, information sharing, and coordinated action. GPN runs what they call sweeps. Every year, authorities across many countries examine the same issue simultaneously. Mobile app privacy notices, IoT devices, children's websites, they publish combined findings. It's soft power, but it shapes industry behavior. There's also the US Safe Web Act, which gave the FTC authority to share information with foreign counterparts and pursue conduct with foreign elements. And then there's the multi-state model domestically. Same logic, coordinate, share, act together. Here's the strategic point for you. A company facing one regulator can manage the conversation. A company facing 8 coordinated regulators cannot play them against each other. Coordination is the whole point. #, self-regulatory enforcement, PCI DSS, and trustmark sanctions. Let's close this chapter with enforcement that has nothing to do with government, and I want you to see how much bite it actually has. PCI DSS is the payment card industry data security standard. Now, is it law? No, not a statute, not a regulation. It's a contractual standard created by the card brands. Visa, MasterCard, American Express, Discover, JCB. So how is it enforced? Through the contract chain. You agree to it with your acquiring bank, the bank agree to it with the card brands, break it, and consequences flow down. Fines, increased transaction fees, and the ultimate sanction, losing the ability to process card payments at all. Think about what that means. A retailer that cannot accept credit cards is not a retailer anymore. That's a corporate death sentence, imposed with no court, no regulator, no due process, just a contract. I've seen clients treat PCI as more urgent than actual statutes, and honestly, the risk calculus supports them. Trust marks work similarly but softer. Violate a trust certification, you can be decertified, refer to the FTC, publicly listed. So here's the lesson. Don't equate legal force with practical force. Some of the sharpest teeth in privacy were never written by a legislature,